Good afternoon, everyone. My name is Merritt Green. I'm the founder and managing partner of General Counsel PC. Here with me today is Anne-Marie Murzin, who leads our estate planning practice. And we appreciate you attending. We will try to finish absolutely by 1 o'clock. If you have any questions, please go ahead and use the questions tab that is within the control panel, the tool panel for the GoToWebinar. And I think with that, we'll start off. And just as we go along, we're sort of going through these 20 questions. It'll be conversational, between Anne-Marie and myself. As I said, please ask any questions that you may have. And, hopefully this is a great informative presentation for you. And if you have any follow-up questions, you can always ask after the webinar also, or set up a meeting with Anne-Marie. So just quickly, a little overview of General Counsel. The firm was started in 2004. We are a general practice law firm. So we work with a lot of business clients doing, corporate M&A work. We do contracts and other things that they need on a day-to-day basis. We do a lot of labor and employment law. Right now, we're doing more, we're in over our heads with COVID compliance matters, government mandates, religious exemptions. So we're doing a lot of employment law, government contracts, dispute resolution, and litigation, in courts, state and federal courts throughout the DC, Maryland, and Virginia. We have a family law practice, and we have our estate planning and asset protection practice that is managed by Anne-Marie. Next, a little background on Anne-Marie. I'm not going to go ahead and review this. We can pass out the slides if anyone needs it, but Anne-Marie's been doing estate planning for a while. She does a great job for our clients here, and it's wonderful to have her here as part of our practice. And again, lots of clients have wonderful things to say about Anne-Marie. I'm not going to go ahead and read this for you all, but you can take our word for it. Hopefully, if you get to work with her, you'll realize how wonderful she is and how she really cares about taking care of her clients. So with that, before we jump in, Anne-Marie, do you have sort of a little introduction that you want to say?
Yeah, no, I appreciate that. Thank you very much. And welcome to everyone. Thanks for joining us. And also want to thank you for all the people who already signed up for consultations, as the materials included the no obligation free consultation. So thank you for that. And please consider taking advantage of this opportunity to make a quick consultation with me, ask any specific questions that apply to you directly. We're going to go through these 20 questions and keep it informative. And again, I appreciate you joining, and welcome to this conversation.
Great. So with that, let's go ahead and start off with some of the basic questions, which is, I don't have an estate. Why do I need estate planning? What does estate planning mean? Oftentimes, and I've thought this myself many times, I don't have an estate. It sounds just so formal. It sounds like we should be in the English countryside, and, having our, outhouses and cows part of the estate.
Yes, that's what most people think. But first, it does not have to be complicated. You don't have to make a mountain out of a molehill. But all estate planning is simply making decisions about what you own, and also about what will happen to your body when you die. And ideally, if the planning is done correctly, best practices also include what happens if you're incapacitated as well. So all of these issues can be addressed in estate planning. And again, it could be simple or it could be complicated depending on, your personal situation.
So really, it's a way to take control over your life, and also what happens when you pass away, as it relates to the most important things in your life. So your property, your children, your finances, and your health. Because I think that's something that a lot of people don't think about is, what happens to them if they're, in a coma or something along those lines. And that's included within, estate planning processes.
And also, it is a way to potentially save money and to make sure that your hard-earned assets are going to the people that you want them to go to, and not the government, and not someone that you do not want to have the benefit of, all of your work and what you own.
Absolutely. I know we're going to go into some of these in a little bit more detail, but question number 2 is, what are the most common tools used in estate planning?
Well, first, there's the will or a last will and testament that most people are already familiar with. There's also a trust, a power of attorney, a pour-over will, advanced healthcare directive, or a living will, and all of the can be used in combination in one estate plan.
Mm-hmm. So there are a lot of different tools at your disposal, depending on really the individual circumstances, of the client or clients you're working with.
Mm-hmm. Yeah, they can be customized for families with children, single people, people who are divorced, husband and wife, any of those combinations.
Great. Question number 3. What is probate and why do I care?
That's a good one. A good definition of probate is an administrative court proceeding that you file with your own money. And it's a way to inventory your assets, distribute your assets, and handle any claims or issues regarding your assets and your debts, but after you pass away, after you die. And usually you need to hire an attorney to manage probate, which you pay by the hour.
So if there's a process there, why do I need a will? Why not just, Virginia, they have probate courts set up at the local circuit courts. Why have a will or do estate planning or have trust or any of that? What happens if you die without a will?
Yeah, I think we're going to touch on that a little bit more later, but right now I'll just say that if you die without a will, it's just a lot more complicated, and then the government, through the laws of intestate succession, decides who get your assets. If you have a will, then it's your own wishes. You're giving instructions to the court, to the probate court, saying, I want this to be done with my assets and my body in this way. And sometimes trusts are also included in probate court, but for the most part, trusts are able to avoid any administrative procedure through the courts.
Mm-hmm. So really then probate, as you said, sort of is the administrative process for dispersing someone's, assets, their possessions, and I think the other downside is I've seen that it's oftentimes 3 months to 2 years to go through the probate process. It could be more. Oftentimes you hear about probate litigation and family disputes, and none of the assets of the person that passed away are going to be distributed during that time. So
the assets are frozen for sure.
So that could really cause confusion. It could cause hardship, and it could really almost create an opportunity for family fights. Oftentimes you hear about, just horrible situations where someone passes away without a will, and they have a number of children, and the aunt comes and says, oh, I was promised all this money, and then their children aren't getting along, and in the worst case scenarios, $1 million or $2 million in legal fees thereafter. The family all hates each other, and a lot of the money of the state's gone to lawyers and not to the family. Then all could have been avoided with proper estate planning.
Yeah, 100%. I couldn't have said it better than that. It's really ideally great to avoid being in court, any court, but then again, also definitely not probate court. You don't want your money to go to that when it could be benefiting other people.
Great. Well, let's talk again about some of the sort of nuts and bolts. What's a medical directive and why do I need one?
Yeah, a advanced healthcare directive or a living will is a way to explain what your wishes are going to be when you can't express them yourself regarding healthcare decisions, medical decisions. So you can nominate someone through this document, through this legal document, and you can distribute this ahead of time to the person who is going to stand in your shoes and explain what you want, or you can upload it to your primary care physician's portal. You can have this information ahead of time, so if anything unfortunate happens, you can already have decided what you want, what type of medical treatment you want.
Okay, so that goes back to, what is estate planning? Why do I need estate planning? Estate planning is a lot more than just what happens to your possessions. It really allows you to have more control over your life. So that single 32-year-old, who has a dog, rents an apartment, and is an active mountain biking, enthusiast, they should probably do some estate planning and have a medical directive, because what happens if they get hurt? They want to have control over, their medical care.
Right. I mean, some of the things you can be specific about, like, do you want antibiotics? Would you want experimental treatment? And do you want, want to be resuscitated? You want to have life support? What you want a feeding tube? How long do you want to stay on? If you're in a coma, just those decisions. If you outline them ahead of time, whoever your family members are, your close friends are going to be there for you. They already know what you want, so they're not going to have to stress. You're saving the people who are healthy. You're saving them from making these decisions, and they know what you want.
Absolutely. Well, and you don't have a potential dispute between, let's say, the hospital and the family, because the hospital might have different perspective on what needs to be done, what is the required medical care, and that may be absolutely different from the person who's sitting there in the coma. But if they don't have a medical directive, probably can't do anything. So the
right,
number
you're just going to go with the advice of the medical team in that case.
So number 5, what's a power of attorney and why is it important?
A power of attorney is another legal document that we often use in estate planning. It's absolutely necessary if you have a will to have a power of attorney, because again, a will only is effective when you pass away. So a power of attorney can allow someone else, someone that you trust, to stand in your shoes to make certain decisions. You're giving them the power to do things in your behalf.
So in the same way that we talked about a medical directive, a power of attorney is something, again, someone who's, healthy, 35-year-old, married or not married, it might be important to have a power of attorney. I know that for a business owner that we worked with recently, we talked about, having a power of attorney, because what happens if this business owner gets hit by a bus, and someone has to come in and make decisions as relevant to the business. You really want.
It can be as simple as, allowing someone to, access your bank accounts when you're temporarily or permanently incapacitated. It could be allowing someone to manage your financial affairs when you happen to be out of the country. So it can be a springing power of attorney, like only in effect in case of emergency, or it can be durable. It could be effective immediately, just if a husband and wife, one goes on a girls trip and the husband's home and needs to go to DMV or, the motor vehicles, whatever, it can take the power of attorney and, make those decisions and sign on your behalf.
Great. So another important tool. So question number 6, what's the difference between a will and a trust?
Yeah, no, we're going to go into this more detail, but basically a will are instructions to a court about what you want to happen when you pass away. And a trust is different, because a trust is in effect during your lifetime, and also if you're incapacitated, and then when and if you pass away. Okay,
so with a trust, you're passing things directly to a beneficiary, and some of it is happening during your life, whereas with a will, it really has to go through the probate process in the court system still. So in certain circumstances, it's another good tool that we have.
But in general, it is better to have, a will is not, awful. It's certainly better to have a will than it is to have nothing at all. So it's better to have a plan than no plan.
Okay. And I guess it also depends on there's no cookie cutter solution here. Everyone's different. So someone that has a $50 million estate is probably going to be significantly different than someone that has an estate worth, $1 million or less. I know we're going to talk about special needs, and then families that are blended families or divorced. All these are different scenarios that can be addressed through planning.
Yeah, you can make it as simple or as customized as you want it. I didn't mention this with the power of attorney, but you can make it, customized to cover, certain finances and not other finances. Same thing with a will and a trust. You can make it as customized as possible. And really, it's one of the great benefits we have. We can use the law as a tool to make our lives better and make, our family lives, our loved ones' lives better as a result of this planning.
Somewhere in the recesses of my brain, I remember that Leona Helmsley, the New York hotel heiress, set up a special trust, I want to say, for her dogs.
I do remember that too. Yeah, you're right.
Do planning like that also.
Yeah, pet trust. Yes, that's the thing.
If you have a parrot, you might want to do it because they live for 100 years or more. So you want to be able to take care of them. All right, question number 7. I've heard of a pour over will. What is that?
So a pour-over will is usually a document that is executed or signed in conjunction with a trust. So a trust is a legal document that you allow to put any assets in. You can envision it like a box. You have a trust and you can put your house in it, or bank accounts, or collections, things like that. Sometimes you don't end up putting everything in the name of the trust, funding the trust 100%. So you have the trust, but you didn't put everything in it. So a pour-over will is a document, an ancillary document that is in conjunction with a trust that pours everything over into the trust that wasn't put in there for whatever reason.
So that makes sense. So, oftentimes you'll put big assets within a trust. So you'll put your house in a trust. Maybe you could put a life insurance in a trust, but all of your clothes and furniture and your 2005 car might not go into the trust. So those would be in a pour-over will, I guess, and the limited assets would still go through the probate process.
Correct. That's true. But it would be a very quick process with this pour-over will. It's a very standard thing. The judge will look at it and be like, yep, we're going to order everything in the trust. Done. Stamped.
Yeah.
So it's
I guess
much,
it's sort of
much
like a safety net, just to make sure that nothing's missed.
Yeah, because it happens that people go through all this estate planning, they have a trust, they fund it, they do everything, and then they happen to go, see a condo that they like in Florida, and they buy it, and they don't put the condo in the trust. They just forgot, to do that, or didn't have a chance. And then if anything happens to them, they're already covered.
Gotcha. Perfect. All right. Question number 8. How are we doing on time? We're doing great. Can I simply buy life insurance for estate planning?
Pretty much no, but you could do that, but it's only one piece of the puzzle. So life insurance can be good to cover your current obligations you have to someone. Let's just say that someone is depending on you to support them. It would be a good safety net in that respect. Or it could cover your debts that you have if you have credit card debt or a mortgage. But it doesn't cover any other issues, like where do you want your property to go? What do you want to happen to your body? But it's a good idea to do it for your family, but it's not the only way. And it's not just, you can't just do that route.
So lots of times life insurance is, part of the estate planning process. I know lots of times when we're working on estate planning, or even business succession planning for a client, life insurance is important part of that. We oftentimes will be working with financial advisors to put all the different pieces in place. I think it's particularly important, to have life insurance with your, 30 to 50 or 60. You have children, who are still in college or something along those lines or younger, to make sure there's sufficient income to pay for those costs. So
people don't often think about estate planning to cover debts or existing obligations, but it does cover that as well. It's not just about your assets; it's also about things that you owe,
or that you want to make sure are taken care of in the future, as it relates to perhaps life insurance. You want to make sure your kids have enough money for college, or the mortgage can be paid off. If your spouse and kids are staying at home. It's for planning for that future and planning in a intelligent way.
And to your point, we definitely want to collaborate, with financial advisors or people like that to make sure that everybody's assets are looked at and what their financial picture is as well.
Great. All right. Question number 9. What are some of the benefits of using a trust?
Well, the huge benefit is that it avoids probate for the most part if it's done right. So that would save you already legal fees, time, costs, expenses. You can make it as specific, customized as you want versus a will. And it also is in effect, again, during your lifetime, if you're incapacitated, and then after when you pass away. You can actually go all the way through future generations if you want. And you can carve out different pieces of assets. For example, you're able to, let's just say that you have a particular nest egg that you want to give to your grandchildren, and you don't want that to go necessarily to your spouse. So you can carve that particular asset out and say, this is going to go directly to my grandchildren in a trust for their education or whatever reason, and this piece is going to go to my surviving spouse.
Yeah, exactly. And I think that, as I sort of think of trust, sometimes they're, absolutely you're avoiding probate, there are tax reasons to do it. So for certain individuals, you can take certain assets out of your estate to avoid certain taxation. Obviously, this is for folks, and now I think the tax is over, I think it's about $23 million combined between a husband and wife. So, it's not a huge group of people that you'd be worried about some of that, but it is a way to reduce tax.
But to your point, though, 40% tax bill above that amount is still a lot.
Oh, absolutely. No, absolutely. The other thing I think you can do, as you said, is having the trust really gives more flexibility to the person. So if you, and we'll talk about this a little bit more, but if you have a child who, you're worried about having spending issues, or is under 18, or, whatever the other circumstances, you can put guardrails up to direct things.
It's a way to really, transmit in a different way than the will what your values are. So let's just say, you are concerned about having them have a good education, but generally you just want them to be able to support themselves. So if they don't want to go to college, you could put a condition, okay, if you don't go to college, if you create a business plan, through a business coach, and it meets these requirements, then you can still get the nest egg even if you don't go to college. So it can be more open-minded, than a will or just a 529 plan.
Perfect. All right, well, let's keep going then, and we're going to get into some more sort of specific scenarios. Number 10, I'm single, live in a condo, I have some savings and a retirement account. What do I need to do? Do I need to actually do any estate planning? And we've probably touched on some of this already, but why don't we just drive it home?
Yeah, I'll just run through it again. It would be good to have a will, because again, if you don't have a will, then the government is going to decide where your assets are going to go, and you have to pay an attorney to go through probate court to inventory the assets, to just distribute them. So a lot of your money, if you only have a little bit of money, it's all going to go to court and to legal fees. So yes, it would be important to do estate planning, at least have a will. And then as to your retirement account, that's an asset that passes outside of probate. So you would need to make sure the beneficiaries are updated for that. And as to the condo, you'd have to decide, who is going to get the condo. So just to follow up, you can consider if it's important to you to have, a living will or a medical directive, if that's something that is concerning you. And also a power of attorney. So that way people can access the accounts that are not going to be within probate, such as the retirement account and any other bank accounts.
I think along those lines, I'll generally always recommend that someone get a living will or medical directive. If no other reason, this single person, passes away, it would be good to provide the parents or siblings guidance on what the person wants, instead of being forced in this time of sort of probably great sorrow to have to make those decisions. It's good to sort of leave some of that.
And oftentimes, if there isn't any planning, what actually has to happen is you have to access the person's email, and you have to wait for what comes through the regular mail to figure out what's happening with all the different accounts. Because usually a single person might not have everything, organized in a way that's easy accessible, their passwords and this and that. And a power of attorney at a minimum would help people figure out what is out there and then how to resolve it.
Great. And one other thing to think about is, and this goes back a little bit to what happens if you don't have a will, which I guess is part of what we're answering here in this question. But if this person passes away and they have their condo and some savings, everything's going to pass via intestate succession. And for that single person, it probably flows back to the parents, and they may have, a woman, or a man that they've been living with for the last 5 years, and maybe they're not married, but they feel like they're married. Well, in Virginia, you don't have common law marriage. So in that circumstance, that person that you're going to have lived with for the last 5-10 years isn't going to get a penny out of your estate. And if you
I've had that exact situation happen, and it was a boyfriend and girlfriend, longtime boyfriend and girlfriend, and they, they lived together, and she actually had substantial amount of assets, and fast forward, it turns out that he had to move out of the apartment, and all of that on a rapid basis. So it was actually pretty stressful for that person.
And she, in that circumstance, may have wanted him to be treated as a spouse, to get money that perhaps she had, earned during their lifetime together, or their time together, or property that they bought together, and maybe he had actually even helped pay the mortgage of the condo, but since he wasn't on the deed, let's say her parents didn't like him, he's out of luck and probably not getting much of anything there. So, that circumstance.
You're 100% right.
I just saw we had a question that come through, and I think this is something we might address in the future, but if we do, we'll skip over it then. Do you have to update your estate planning documents, or is it a one and done set of documents?
Excellent question. It depends, but life is fluid. So when things change, it would be a very good idea to update your estate plan. The best practice is you update it every 3 years approximately. But the laws change, so it's important to stay in touch to make sure that you're up to date and getting all the benefits possible through your estate plan. But if you move, if you have a child, if you are about to retire, if you're divorced, your relationship status changes. No, it's not really a one and done situation. It's kind of like you want to maintain a relationship with whoever did your estate plan, or start a relationship with us, and we'll keep in touch with you and make sure that you're informed along the way.
I think you definitely want to start a relationship with us and Joe and Anne Marie. And I think it's exactly as things in your life change, all of those major life activities. We work with a number of realtors, and someone buys a house. That's a good time to think about putting in a will if you don't have one already, or a child is born, or another child is born, or a parent passes away, and all these different life activities. That's when we really want to think about
to
it.
your point about buying a house, that's actually a perfect opportunity that people don't really think about, to do a trust ahead of time, because that way you can do everything all at the same time. You can purchase the house and place it in the trust all at the same time. So that's a good idea. It's very efficient.
Yeah, absolutely. Question number 14. Where am I? Nope, I'm sorry. We're in question number 11. Trying to get ahead of ourselves.
You want to be done already? I thought I was trying not to be boring, Merritt.
No, we're doing great. All right. And we're about halfway through the questions, and we're at 27 minutes. So we're doing wonderfully here, timing-wise, too. My husband and I are separated and likely getting divorced. And we have, wills together. Let's put that into the facts also. Should I update my will or consider a trust or something else?
That's a very quick answer. Yes, you absolutely run to an attorney, run to us right away, and we will help you. Because if you don't, everything that you own will actually go to your husband before you are divorced.
And that's interesting. And if our family law attorney were here, I'm sure she'd drive this home even more. But Virginia has a 1-year waiting period if you have children. So you need to be separated for a full year, and before you can officially get divorced. So if during that time, something were to happen, I always use the example: you get run over by a bus. You may be really not like your spouse. Your spouse might have been cheating or other, issues. But if you haven't updated your will during that time, this person who you may not like very much anymore could be getting all of your assets. So I think that would be a really good time to put in an updated will, set up a trust, especially if your children are minors, so that some of your assets are put into a trust and go to the children. Look at your life insurance, your retirement plans. All of the beneficiaries for those should be changed.
And on the flip side, if you guys are actually having an amicable separation, it is an opportunity to make sure you're all on the same page. If anything happens to both of you, about temporary and permanent guardians, if you have minor children, and things like that. So through our family law attorney, we also incorporate those documents. So if there's a co-parenting plan, for example, we can reference that in your estate plan, so everyone is on the same page, not just about your current life, but in case of emergency, what should happen.
Oh, absolutely. All right, question number 12. My daughter is married. If she predeceases her husband, who has children from a prior marriage, how can we make sure he does not inherit our money? So I guess mom and dad don't really like their daughter's husband, and if she passes away, or if the daughter passes away first, want to make sure that the husband, isn't left with a lot of the family money.
Well, again, you can do a will or a trust. In this situation, I would recommend a trust just to keep things out of court and keep it private. That's one benefit of a trust that I didn't mention earlier, that a will is public versus a trust, everything remains private. So if you have a trust, you can do a generation skipping trust. So it would skip the daughter and go right to the grandchildren. And you can also, like I said earlier, be specific. You could make sure you protect against their financial immaturity. You can give it money to them in certain conditions and carve it out and keep it all private. And the surviving spouse wouldn't have any information about the estate plan.
So I guess that you have the flexibility of a trust. So in this circumstance, could you set up a trust whereby perhaps the daughter, while she's still married, has access to these monies? Perhaps there are guardrails in what she can do. So she can't go out and buy a $500,000 house, but she can use it for education and other, care of, herself and the children and incidentals of the family. But then if she passes away, the trust is still in existence, and it's directed that the monies go directly to her children. And the trust probably still is in place, and there's a trustee who is not the husband, so he's still then, those guardrails are still there, and he still can't take the money.
Mm-hmm. Absolutely.
A question for you in the circumstance: do you have the same flexibility sometimes in a will that you would a trust? So could you have a will that says, if the daughter predeceases, that her husband doesn't get anything?
Yeah, you can use the, I'm just going to complicate this a little bit. We're halfway in, so I think everybody knows these general terms. So let's just envision you have a will. You actually can have, if certain circumstances are met, you can actually ask the court to create a trust to benefit your grandchildren. So you can create a trust on the front end, so ahead of time during your lifetime, but you can also have a testamentary trust. So if certain conditions are met, the judge can say, okay, I see these conditions are met, we'll create a trust for the grandchildren. But again, the surviving husband would be aware of all these proceedings and would be able to follow a claim or, try to slow these down or, cause some type of dispute about this because a will is public. So the answer is yes, but.
And it sounds like so much more complicated. Why would you ever want a judge to have to create a trust when you could do it yourself during your own lifetime and explicitly state what you want to get done? So.
Right. Well, some people would rather not pay, up front, and they want to, do it, have a cheaper option through a will, and then you have to pay attorney's fees to the court, to the judge or to attorneys afterwards if those certain conditions are met. So it's just a different procedure, apples and oranges, really.
All right. Question number 13. My grandson is great, but he struggled with addiction and debt for the past several years. What can we do?
This happens a lot. People come to me often and they want to treat all their children equally. But as we all know, kids are all different. They have different circumstances. You might have a musician. You might have someone who is, goes to, 4-year educational opportunities. You might have someone who goes in the military, and you might have someone like the grandchild who's in and out of rehab for whatever reason, and you want to treat them all equally. So a trust is a good option to make sure that you can treat them all equally. But if they have these certain, issues, you can make sure they don't have access to the money until it's appropriate.
Gotcha. We have another question. Can you set up your trust to protect it when your kids grow up so people can't try to use them to get the money? Pregnancies,
yeah, that's really, really great question. Yeah, the predator question, because that is true, And one thing I tell people is if you do have a trust, you don't actually have to put it on your checkbook. So when you write a check, everyone can see that you have a trust. You can keep all that, private. That can just be semantics. But yes, that's a great idea to do it ahead of time. So that way, when they get older, they can make sure that they are still provided for, and you can shield it from any potential creditors, or if they get divorced, things like that. You can make sure that they still have the benefit, but also protection. Good question.
Is that something that's called a spendthrift trust? Or is that particularly set up to protect assets in that circumstance, or are there different types of trusts you can set up also?
There's different types of terms within trusts, and the different terms basically mandate what the trust is called. So within each trust, but the way we do estate planning here is we make sure we look at everyone's individual circumstance and we put in the specific clause that will be relevant in the future. So we do the contingency planning for you because, you know, we've seen all this before. And based on your individual situation, we would suggest maybe we want to do this, maybe we want to do that, and then the client can decide, you know, what they want in their particular trust.
Gotcha. So you can have spendthrift provisions, you know, or whatever else.
Yeah, and even in a will, this goes back to that prior question, you can put in a special needs trust just in case. So if you have a grandchild who later develops some type of disability or injury or what have you, their distribution could be created into a trust, so that way it protects the benefits, the government benefits they could be eligible for, and make sure that the funds go directly into that trust on their behalf.
Great. All right. Question number 14 now. We recently purchased a home. Should we update our estate planning?
Yeah, I think we answered that one. So that's yes.
All right. And that you might even want to consider putting the home into a trust, and there are different types, you know, that you might want to consider. All right. Question number 15 then. I am a divorced dad with 2 kids from my first marriage. Now remarried, expecting another child with my second wife. Although I always hate the term second wife. It should just be my wife. The second implies there might be a third with my wife.
Are you revealing a little bit about yourself?
Well, you know. How can I protect all of them except my ex-spouse? That may be implying something there. But so divorced, 2 kids from a first marriage, remarried, have another kid on the way. You know, what can I be doing from an estate planning practice to, you know, protect, you know, my wife, 3 of my kids, and make sure my ex-spouse doesn't get a penny?
Yeah, I mean, first of all, it's wonderful to be able to think about this, that you want to, you know, care for everyone, you know, that you have, you know, kids
Except
from
the
your prior
ex-spouse.
marriage, and, you know, your current wife, and, you know, so it's generally, it's a wonderful position to be in and wonderful thing to have, that, you know, the person's remarried. So people often think, oh, I can't do estate planning because it can be too complicated. My life is too complicated for estate planning. It's going to be too expensive. When in fact, you're actually saving everyone money by just doing a little planning, which only takes really 2 hours to do planning. I do most of the work. You just have to give me the information. So in this particular situation, it would be perfect for estate planning, because you'd be able to carve out any type of assets or whatever gift it is you want to provide your children for a first marriage. And often these children are older, so, you know, their needs could be different than the younger child. So you might have children who are, you know, over 18, for example, you know, they're 24, 25, 26, and then you have someone who is 10 or 11. And, you know, as we know, that's a different scenario. They have different needs, right? The 10 or 11-year-old might want to stay in the house with the current spouse. And then the older kids are probably already out of the house, but you want to make sure they're provided for as well. So again, you can do this through a will, but it would be better to be very specific with a trust about where you want your assets to go and what you would want to happen if you happen to pass away. And then, you know, a trust also is in effect if you're incapacitated. So that protects your current obligations to your prior kids. You would make sure that they would be taken care of, and the money wouldn't go to the first spouse. It would just be to provide for the children's needs. And then during the same time, you know, your second child's life wouldn't have to be disrupted, and your second spouse would be provided for as well. So it's an easy thing to do. It's not complicated. We do that all the time. And I hope that answers the question.
No, absolutely. And the other thing is, I know that oftentimes while going through a divorce, you know, the family will have a marital separation agreement, and there could be either spousal support or, more importantly, child support obligations. You know, let's say you have a child that's 5, you might have 13 years of child support obligations potentially, and oftentimes there'll be a requirement put in for life insurance, you know, and that life insurance is put in to fund those ongoing child support obligations. So in that circumstance, you might almost want to have 2 life insurance policies, One, for the sole purpose of, protecting the child from the first marriage and funding child support obligations, and have that in a trust with a trustee, and the ex-spouse has no control over it whatsoever. And then the other life insurance, the beneficiary is your current wife. That's something I've seen quite a bit. All right, so next question is, I have a special needs child. What estate planning options do I have?
You definitely have a lot of estate planning options, but a lot of times people are asking this question because they want to protect monies and have certain money set aside just to care for the child. So that is a huge piece of taking care of a special needs child. But the other piece that people often don't realize is they can also incorporate and specify certain things that the special needs child is used to. For example, are they used to a particular school or educational opportunity? Are they used to particular extracurricular activities? Like, do they go to the Y on Tuesdays to swim? Do they like to go to a certain park? Do they like being around animals or going to the zoo? So you can be very specific about what would be helpful to care for the child and reduce their stress, in addition to making sure that they're still able to access the certain government benefits that the child relies on, and making sure they have money to go to their care. Does that make sense?
It does. All right, question number 17. I read that some trusts are used for tax planning purposes. How common is that?
It's actually very common. It depends on the particular situation. We mentioned earlier that the federal tax exemption is currently, 11.7 million. So it only applies to certain people. But you do also have to consider state tax law as well. That's something that people also use to plan with. But there's various different options. So you have a trust where you can retain the income on an annual basis, for example, and then you can gift the bulk of the asset to someone, and that saves a lot of tax benefits. There's a life insurance trust, a revocable life insurance trust, various types of trust that can use for tax planning purposes. And again, we look at the specific situation to see if it would apply. And then also, I have to mention that the tax laws are likely to change probably at the end of the year. So if you have an existing trust right now, you might need to reach out to us and let us review it to see if it's going to be affected if any tax laws change. And if they do, we might need to help you modify that and take some steps to protect against any tax law changes.
So for the federal tax purposes, I guess what I've read is that where the exemption now, as you said, 11.7 per person, it might actually be decreased. So there might be more people that actually, may need to do this tax planning.
Yeah, it's actually set to be divided in half. People are expecting.
Okay. And a lot of the use of trust in that regard is taking certain assets out of the taxable estate. So you look at each, family, individual, and what are some of the assets that are very valuable, and how can you take them out of the taxable estate? So if you have residence, you can take out, there's something called, I guess, a qualified personal residence trust. And there's, as you mentioned, life insurance trust. For business.
I don't think we mentioned this yet. We probably should have put this as one of the questions about a charitable remainder trust. How to donate monies to charities. I actually call it the doomsday question. So if everyone you know and care and love very, very much passes away, what do you want to happen to your assets? Do you want to give it to the Red Cross? Is there a particular charity that's near and dear to you? You don't want the money to go to a government. So best practices for estate planning, whether you have a will or a trust, is to consider what happens if all the people you named in your estate plan pass away. Then what? And as regarding this question, there is the charitable remainder trust. So that's one way to handle it. We actually have that one current client that's interested in creating his own foundation, remember? So, that's a possibility too. So tax planning purposes, but also charitable giving is just a wonderful way to do estate planning.
And that's where oftentimes we are working with financial planners. Occasionally we'll also be working with the CPA of certain clients thinking about the charitable remainder trust, again, you need to look at particular circumstances of each, person or family. But if you bought Apple stock, 25 years ago at $5 a share, and it's now worth whatever it is, $1,000 a share, oftentimes something like that might actually be put into a charitable remainder trust because there are a lot of tax advantages for doing so, where you don't have to pay tax on some of the appreciation, but you can get the tax deduction currently. So again, there's planning that needs to be done in certain circumstances, oftentimes, in conjunction with your CPA.
And one other piece that people often forget about is that what if you don't use all of the money that is set aside in your retirement account? Is there a way to provide a retirement account, give someone as a head start with their own retirement account that you didn't use? And you can do that through trust as well. So plan for your retirement, give them your retirement, because we all know how hard it is to save on a regular basis and set aside monies. And if you can use that as a legacy, what a wonderful way to get people started if their retirement is already taken care of in a fund.
All right, question number 18. I plan to move when I retire. Should I just wait to do my estate planning until after I move?
No, please call us right away. I know I'm being facetious, but really there is this portability concept. So if you sign a will, in California and you move to Florida, it's up to the state of Florida where you move, whether they find that acceptable or not. So while the answer is it depends, and usually it's better to make sure that your plan complies with the current state laws where you move. So you can do it ahead of time and make sure you plan during that. And then once you move, make sure that we talk to you to make sure all the provisions are updated, and also that you're taking advantage of the law of your new state. There could be a positive reason to do estate planning, once you move. So do it now, and then, we can check and update it.
Yeah, I think that's important, is that you just don't want to wait. You're going to retire and move to Florida in 5 years. You don't want to go 5 years without having a will or trust or other planning in place, because again, what happens if you are hit by a bus?
Well, and also it's actually not as complicated as people think to do an estate plan. So there's no real reason to wait. It really, there's a little bit of pre-planning before we get together. So, inventorying some assets and making some decisions, and the ones you can't make, we can help you come up with a logical formulation about, the best situation for you. And then we just sit down for, an hour and a half, 2 hours, and then you're done. You come in and you do the signing. So it's not like a big, huge, month-long process to have to worry about.
And maybe you could save a little bit of money by waiting 5 years, until you move to Florida. But what's the risk? It's the same thing with life insurance. Why buy life insurance? Knock on wood, you're not going to pass away, but you have it there just in case.
Right. People actually ask me, if I come meet with you, am I tempting fate? And I'm going to tell you, based on my experience, absolutely not. Everyone that I've worked with are actually still alive.
Question from the audience. And they provide a caveat if we're willing to share this information. So, Anne Marie, I leave it to you, and I'm sure you'll give a lawyerly answer, which is, what's the approximate cost and range for a detailed estate? I'm sure there's a broad range, but curious what that is. And obviously,
yeah, reach out to me for sure. My email address is on these slides, and I think the information is also included ahead of time with the registration. So reach out for me, and I can, give you more of an idea when we talk, because it's hard for me to know whether it's simple or complicated. Are you a single person? Are you married? Do you have children? Do you don't? And what were you thinking? Like, how customized are we getting? But generally, my hourly rate is $4.50 an hour. But here at the firm, we actually provide a bundle or a package situation for estate planning. So we have flat fees. That way we don't nickel and dime you along the way. So we practice in a new way to keep it flexible. And also our plans are able to be updated every 3 years. And again, not nickel and diming you. So I think we're pretty fair the way we price things out, but call me and let's talk about it.
Yeah, but again, I think along those lines, that from a simple will, it could probably be, $1,000 or so, up to, 50 or $100,000 or more if there's really sophisticated planning. So I think there's a
True,
huge.
but keep in mind, we're not just like doing one document. We're actually advising people about, their assets that are not within that probatable estate. So we're advising them about, their checking and savings account, making sure they update their beneficiaries with the retirement plan, things like that. But also the power of attorney is included, the medical directive. We go through each of those different scenarios, what type of healthcare they would want. That's included as well. And some
Great.
people even want to include their final disposition, what's going to happen. They want to be cremated, not cremated, buried, left on a mountaintop, gone out to sea, whatever.
I think all of that should be contemplated at least. Question number 19. I'm a small business owner. My family depends on my income. Is there a way to protect them with estate planning if anything happens to me?
Yeah, this is a really great question, and it is again a wonderful problem to have a business that's having so much growth, and you want to protect your family. So the first thing that we mentioned earlier is to make sure that you have a power of attorney, so someone can still run the business if and when anything even temporarily happens. If you're just temporarily in the hospital. With estate planning, I would recommend a trust, but also we would incorporate the corporate structure, whatever that might be, the LLC, in conjunction with wherever corporate structure it is, with the estate plan. So we look at it as a thorough approach, and like a battle plan or a contingency plan. If this happens, what about this? And we make sure that we address all those different issues so your business can still run. And also we do business succession planning. So who's going to take over the business if you do pass away? And so that's included as well.
Yeah, and I think for small business owners or business owners in general, there's a whole bunch of planning that can be done, and it depends on whether it's a business that's really primed to grow. If it is a smaller business that's more just income producing, it's probably not going to grow a lot, but it's an asset. It's a significant asset of the owner. So, and if you have multi owners within a business, do you have a buy-sell agreement within your operating agreement or shareholders agreement? So there's a lot that we can do for the small business owner. That's part of our planning processes. And oftentimes Anne Marie will work with our corporate attorneys, as we're working with and going through some of their corporate documents and other things along those lines. So.
Yeah, and in the same way that we work with our family law attorney, we have a team approach, and we tap into the expertise of our corporate attorneys. We get their advice on, for the power of attorney, for instance, what state should we have that power of attorney, which state law, and we consider the different structures that they have. But also, we analyze, we do a deep dive into the corporate documents to make sure that we are dotting all the I's and crossing the T's and making sure that the business owner is prepared and that the loved ones who survive can still depend on that income or be in a position to sell the company if possible.
Yep, absolutely. And try not to sell it in a fire sale circumstance, where you're getting pennies on the dollar instead of real value.
A little bit of planning ahead of time can save so much in that situation. Same, even if it was a personal, not a business necessarily, but you have a house and you don't want to necessarily have to sell the house right away to cover people's debt. So if you do a little bit of pre-planning ahead of time, then you end up saving so much, not just stress, because this process can end up being like a part-time job, so going to probate is actually like a part-time job. It's something you have to answer emails, file papers, go to court, doing all of this. So if you meet with us ahead of time, we make sure things are streamlined, and also, I don't know, in general, I think people say they feel like they have peace of mind and clarity. They're better able to live their life if they do some estate planning. Excellent.
All right, question number 20. And I think we're in sort of perfect timing here. In your years of helping clients with estate planning, what's the most important advice you can provide them?
Yeah, I love ending this way. The most important advice is really communication. Communicating to your loved ones what you would want to happen if anything unfortunate occurred. So if you were incapacitated or you passed away. So communication, just telling people what you want, thinking about it and sharing it with them. But not even just about your assets, but communicating with them on a regular basis, telling them how much you love them and appreciate them. So my advice would be communication, say what you've always wanted to say and say it today.
Well, that's way beyond just, legal advice and estate planning. That's, life advice. So
Well,
you can even get that for free.
it's the attorney and counselor part at law.
Mm-hmm. Well, excellent. Well, I think we've answered some of the questions that were presented. So thank you for everyone that provided questions to us. And you have Anne Marie's email here. And if there's, you want to set up a consultation with Anne Marie, I think you have her information there. We're happy to meet with anyone. And thank you all very much. Last words of wisdom, Anne Marie?
Really, thank you so much for joining and being open to this conversation. You're already ahead of the game by wanting to learn more. So I encourage you to take the next step and give us a call or, set up one of those free consultations. And I look forward to connecting with you sometime soon.
Excellent. Well, thank you so much. And everyone, take care. Now I just have to end it properly. There we go. Take care, everyone.
Got it.